Welcome to the deep dive. Today we're tackling, well, a really significant topic. Artificial intelligence, AI, and automated systems, and how they are fundamentally changing the judiciary across the globe. Yeah, our goal here is to cut through some of the hype, the Robo-Judge headlines. We want to dig into the actual sources, Council of Europe, Australasian Institute of Judicial Administration, and see what tools are really being used in courtrooms now. Where do they help? And critically, where do they pose risks to justice?
It's definitely a fast-moving field, and it's global. The Council of Europe's CEPEJ Resource Center, they're tracking this, and they've already identified about 125 different tools out there, mostly in Europe, aimed at judicial efficiency.
1 in 25, okay.
Yeah, but here's the immediate, crucial point that kind of frames everything we'll discuss. Sources are clear that there are no fully autonomous AI systems making independent judgments right now. Human oversight is still mandatory.
Right, that's a really important distinction to make up front. So we're not talking about sci-fi judges. We need to understand what AI in law actually means then. It seems like a broad term.
It is very broad. It covers multiple fields: machine learning, natural language processing, expert systems.
Okay, so let's break that down. The sources seem to talk about almost 2 generations of these tools in the legal space.
That's a good way to think about it. The first generation is probably less exciting to the media, but it's very foundational. We're talking expert systems.
Okay.
Sometimes just called traditional programming. They run on explicit rules. Humans have to provide every single if this, then that instruction. They don't learn or adapt on their own.
So like a sophisticated checklist.
Essentially, yes.
Yeah.
Think of a simple decision tree. If you're over 18 and a citizen, then you can vote. Or, a bit more complex, translating legislation into machine-readable code. That's rules as code, or AC.
Ah, RACES. I've seen that term.
Yeah, it's mainly for administrative tasks. Calculating benefits, checking tax compliance. The system isn't interpreting the law's intent. It's just executing predefined steps based on the coded rules.
Got it. So that's generation 1. Then comes the one everyone talks about, machine learning, ML.
Exactly. This is where the systems do learn. They analyze huge amounts of data to find patterns, and crucially, they improve their performance with more data, more experience.
But that learning process isn't like human learning, right? The sources mention this.
Not at all. A child sees a few cats, they get the concept. A machine learning model might need thousands, millions of cat pictures. And this hunger for data leads to risks, particularly overfitting.
Overfitting. So the model learns the training data too well, including its quirks and noise.
Precisely. It might perform brilliantly on the data it was trained on, but fail badly when it sees new, slightly different data. It hasn't learned the general principle, just the specific examples it saw.
And if you're using that to predict, say, court outcomes, a high accuracy score might actually be misleading if the model is overfitted.
That's a huge risk. Is it learning legal principles or just spotting irrelevant correlations in the historical data? We see ML in various forms, some decision trees which, interestingly, have been used quite successfully to predict U.S. Supreme Court outcomes. Yes, with some success. And then you have more complex models, like neural networks, deep learning, inspired by the brain, used for things like analyzing handwriting or even facial recognition. But again, sophistication doesn't guarantee accuracy or fairness if the learning process goes wrong.
Okay, so we have rule-based systems and learning systems. Let's see them in action. Where did they first start appearing in the courts? Seems like administration was the logical first step. Efficiency gains, less controversy, maybe?
Absolutely. Low-hanging fruit. Think automated e-filing. It's often just rule-based, but the impact is enormous.
How so?
Well, the UK Crown Court, for example, reported saving over 100 million sheets of paper. And think about errors in divorce filings. Simple procedural errors apparently dropped from something like 40% down to less than 1% with electronic systems guiding users. That's real efficiency.
Wow, okay. That's significant. And courts deal with so much text, spoken, and written, so natural language processing, NLP, must be involved too.
Definitely. Real-time transcription services, like those used in some Chinese courts, according to reports, rely heavily on NLP. And legal research tools that let you search vast case databases using natural language questions. The accuracy of speech to text has improved dramatically, making these tools genuinely useful now.
And this connects to resolving disputes too, right? Online dispute resolution, ODR.
Yes, ODR systems often blend technology, maybe expert systems guiding users through options with human mediators or adjudicators. British Columbia's Civil Resolution Tribunal is a well-known example, or the UK's Money Claim Online. The goal is often access to justice for smaller claims, making it cheaper and faster than going to court traditionally.
Okay, so far so good. Efficient filing, transcription, handling small claims online. These seem like mostly positive developments, helping the system run smoother.
Generally, yes.
Yes.
Administrative tasks, low-value disputes, AI offers clear benefits there.
But there's always a but, isn't there? This is why we pivot. What happens when these tools move beyond administration and start influencing litigation strategy, or even supporting high-stakes decisions, like sentencing?
Right. This is where the complexity and the risks really ramp up. A key area is technology-assisted review, or TAR, in discovery.
Discovery, the process of finding relevant documents for a case.
Exactly. In big corporate lawsuits, you might have millions of emails, documents. Traditionally, teams of paralegals reviewed them. TAR uses machine learning to sift through and classify these documents much faster.
And how do judges view this? Are they digging into the algorithms?
Interestingly, not always. There's a quote from a U.S. magistrate judge who basically said he was less concerned with the black box science of the software and more focused on whether it actually found the relevant documents accurately, high recall, high precision. It's a pragmatic, results-oriented view in that context.
Okay, pragmatism in document review. But what about predicting the outcome of a case itself? Case outcome prediction.
That's happening too. ML models are being trained on past decisions from courts like the Australian Federal Court, the French Court of Cassation, even the European Court of Human Rights, trying to predict future rulings.
And are they accurate? I saw a figure 92% for the French Supreme Court.
That figure exists, yes. But we have to be really careful with numbers like that.
Why? Because of the overfitting risk we talked about.
Partly that, yes. But also, what's the baseline? If, say, 80% of appeals to a certain court are dismissed anyway, predicting dismissed gets you 80% accuracy without much intelligence, the model might just learn that simple baseline. Or worse, it might latch onto irrelevant factors. Like maybe it learns that cases argued before Judge Smith tend to go one way and cases before Judge Jones go another. It's predicting based on the judge, not necessarily the legal merits. We need to know what it's learning from.
That lack of transparency seems crucial. Which brings us to the most sensitive area, risk assessment tools in criminal justice. The COMPAS system in the U.S. is the big example here, right?
It is. Correctional offender management profiling for alternative sanctions. It's used in many states to generate scores, predicting the likelihood someone will fail to appear in court, or reoffend generally, or reoffend violently.
And these scores are used in sentencing, bail decisions.
Yes, pre-trial release decisions, sentencing considerations. There's the documented case of Paul Zilli, where his high COMPAS risk score was apparently a factor in rejecting a plea deal. He ended up with a 2-year prison sentence instead. The human impact is undeniable.
So judges are actually using these scores. What's the legal standing?
It's been challenged. The Wisconsin Supreme Court looked at COMPAS and said its use is permissible, but with very important caveats. It cannot be the sole or determinative factor in sentencing.
So it's just one piece of information.
Supposedly. Judges have to be informed about its limitations, the potential issues, and they must still exercise their own independent judgment. But the influence is there.
This feels like the heart of the conflict. Moving from efficiency tools to things that influence core judicial decisions, it really puts different values head to head.
Absolutely. Efficiency versus fairness, transparency, equality. And the biggest single problem that emerges across the sources is bias. The old computer science adage, garbage in, garbage out.
Meaning, if the data used to train the AI is biased, the AI's predictions will be biased too.
Or worse, it can even amplify existing societal biases present in that data. We saw this outside law with Amazon's recruitment tool, remember?
Right. It learned to downgrade women applicants because it was trained on past hiring data from a male-dominated tech workforce. It basically encoded the historical bias.
Exactly. And in the justice system, the stakes are obviously much higher. ProPublica did a well-known investigation into COMPAS.
What did they find?
They found significant racial disparities. Specifically, black defendants were far more likely than white defendants to be incorrectly flagged as high risk for future offending false positives, and white defendants were more likely to be incorrectly flagged as low-risk false negatives.
Even when controlling for other factors.
That was their finding. And the sources suggest this isn't because race is an input variable. It's likely because the algorithm learns from historical data that reflects biased policing or sentencing patterns. Things like zip code or prior arrests for minor offenses can act as proxies for race. embedding that bias deep within the model.
So bias can sneak in through the data itself.
It can enter at the concept stage. What are we asking the AI to predict? At the data collection stage, is the data representative? Or at the model building stage itself, how is it weighted? And there's also the risk of underserving minorities if the training data is skewed, like speech recognition struggling with certain accents because it was only trained on majority voices.
And this links directly to another major problem, accountability and open justice, the technological black box issue.
Yes. Many of these systems, especially commercial ones like Compass, are proprietary. Their algorithms, how they weigh different factors, the source code, it's all confidential trade secrets.
So the defendant, their lawyer, even the judge, can't fully see how the risk score or prediction was generated.
Often, no, not in a meaningful way. And this fundamentally clashes with the principle of open justice, where courts need to provide clear, understandable reasons for their decisions. If a judge relies heavily on an opaque score, the reasons they give might just be a narrative trying to justify a conclusion reached by inscrutable math.
It sounds like it makes challenging the decision incredibly difficult. Procedural fairness.
Exactly. Due process includes the right to understand and challenge the evidence against you. How do you challenge a Compass score if you don't know precisely which inputs led to that score and how they were weighted? It erodes that fundamental right.
And even for the efficiency tools like ODR, there's a tension.
There is. While ODR enhances access for small claims, proposals like the one discussed in Estonia, an actual AI judge for claims under €7,000 raise serious questions.
An AI judge? Seriously?
As a proposal, yes. The idea is you could appeal to a human judge. But can a human judge meaningfully review a decision made by an algorithm whose internal logic might be inaccessible? And does automating judgment, even for small claims, remove the essential human elements, empathy, discretion, the dignity of having a human hear your case that are part of justice?
Right. So pulling this all together, looking across the board, there's this clear split, this duality. AI is undeniably powerful for efficiency, for access in some areas, getting past paper, analyzing huge data sets.
Huge gains there, absolutely.
Yeah.
Streamlining the back office, providing tools for lawyers.
But the moment it crosses into decision support, especially high-stakes decisions, it slams right into core judicial values, impartiality, transparency, accountability, fairness. The speed comes at a potential cost.
That's the crux of it. The debate isn't really whether to use AI, but how and with what safeguards, especially in sensitive areas like criminal justice or family law. The consensus seems to be moving towards needing transparency, auditability, and ensuring systems are designed to be non-discriminatory from the outset. Human oversight remains key. Utility is good, but it can't override fundamental justice.
A critical balance to strike. Okay, before we wrap up, here's a final thought, something maybe to mull over, building on that rules as code idea we discussed earlier.
Okay.
As governments get better at translating laws directly into machine-readable code, what happens down the line when judges aren't just interpreting the natural language text of a statute, but are asked to interpret the computer code itself? Could that fundamentally change what statutory interpretation even means?
That's a fascinating question. Interpreting code versus interpreting legislative text.
Yeah, that could be a very different skill set, a different form of reasoning entirely. Definitely something to think about.